Given the subject matter of this case, which is incredibly important, the allegations raised in this case, which are incredibly serious, we will do better than that. This is not a Jerry Springer show.
All rise. The Second Judicial District Court of the State of Nevada is now in session. The Honorable Egan Walker presiding.
Thank you all very much for that courtesy. Please be seated, ladies and gentlemen. This is case number CV 22-02069, generally entitled Mathews versus York. Appearances for the record, please.
Yes, Your Honor. Jason Guinasso here on behalf of Tirzah Mathews.
Mark Simon on behalf of Marilyn York and the law firm.
Good afternoon.
Afternoon, Your Honor. Frank Gilmore on behalf of Ray York and his company Law Profits Inc. Mr. York is in the court.
Good afternoon. Welcome all. I apologize for the delay, ladies and gentlemen. I guess there was an issue related to court technology. It ends up being the bane of our existence for some reason. But thank you for your patience. And here we are. There are a variety of there are a variety of issues that have been raised subsequent to the filing of the complaint in this case. But I want to begin with some sua sponte action, which may change the tenor and or process of the proceedings this afternoon. And it bears some observation and explanation, I guess, to lay the groundwork. So, outstanding, of course, are a variety of issues, most notably, for purposes of my commentary now, a motion to disqualify Mr. Guinasso and his firm, and a motion to dismiss on behalf of Ms. York and her entities filed in this case. And as I read and reread and reread that motion work, because I'm dim-witted, eventually some observations came quite clearly into focus for me. What I mean by that is this. For example, is the motion to dismiss complains in one facet that allegations against Ms. York individually are not adequately developed in the complaint. And to my eye, there's candidly a good deal of merit to that. And so I thought to myself, intellectually for the moment, I'm not ruling this way, by the way, Mr. Guinasso, I'm thinking out loud. I thought to myself for a moment, well, how am I going to dismiss or how am I going to carve up this complaint for purposes of granting such a motion to dismiss? There's an explanation by the plaintiff through her counsel that Ms. York has some respondeat superior liability in this case, as an additional example. Well, that is nowhere detailed in the complaint. And so I thought that has some merit. And as I started intellectually thinking about each issue, kind of one after another, I really had to dig into the complaint. And the more I dug into the complaint, the more upset I became. And here's what I mean by upset. I can't, from the bench, craft or recraft this document. So this is the complaint and the exhibits. It totals 384 pages in length. The complaint, the pleading portion of the complaint, is 41 pages in length. The complaint has some very unusual, and I keep saying complaint, it's really an amended complaint. I'm referring to the document filed December 23rd, year last. It's really an unusual document. As an example, it contains a demand letter. A demand letter for almost no purposes that I'm aware of would ever be admissible in this case. It traditionally would never come to my eyes absent some finding of liability or concerns about an offer of judgment or allegations of misconduct in some way. But it is prominently attached as an exhibit. In addition to the demand letter, there are transcripts, or purported transcripts of a thing entitled a confession call that purport to record Mr. York's salacious motivations, for lack of a better way to describe it, and the details of his harassment of Ms. Mathews. Let me drop a footnote and say, please understand, Mr. Guinasso and Ms. Mathews, the lens through which I view this complaint is assuming it to be true. Let me say that again. The lens through which I view this complaint is assuming it to be true, because of course we're in the context of a motion to dismiss, and I must assume it to be true. And so these salacious comments by Mr. York are there. But of course, those comments aren't necessarily admissible against anybody except Mr. York, as an example. There are copies of emails, text messages. There's an entire exhibit. Exhibit 19 is almost 200 pages in length that appears to be a copy of a website or websites that are incredibly destructive to and damaging of Ms. Mathews, that are apparently contain forged documents and a variety of information that likewise may or may not be admissible, may or may not be relevant, but has never in my experience before been contained in a complaint. There are references throughout the complaint and the exhibits attached to the complaint to sex toys. We're all grown-ups in this room. This is an adult proceeding, but there are references to sex acts, the so-called altar. There are multiple references to something I decline to say on the record, but a plumper of some kind that is described using a term that's a derogatory of a woman's anatomy. And at the time that I read that third reference in the complaint, I realized I have a duty to act. And the duty to act is illustrated by a rule. NRCP 8A describes the nature of pleadings in a case like this. And it reads as follows. Entitlement, claim for relief. A pleading that states a claim for relief must contain, number one, a short and plain statement of the grounds for the court's jurisdiction, unless the court already has jurisdiction and the claim needs no jurisdictional support. Well, there is a short and plain statement of jurisdiction in one of the paragraphs of the complaint. Number two, a short and plain statement of the claim showing that the pleader is entitled to relief. I'm reviewing my notes, I apologize. There are 17 causes of action alleged. And I cannot tell which of the numerous paragraphs and exhibits is intended to apply to which of the assertions in the complaint. As a reader of the complaint, I cannot discern that. That is problematic. And a motion to strike a complaint is controlled by rule. Nevada Rule of Civil Procedure 12 describes a variety of remedies, processes, etc. And 12F is entitled Motion to Strike and instructs the court may strike from a pleading an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. The court may act, number one, on its own. So gosh, what do you know? I read the rules and I realized I have an obligation to act. When I looked for definitions of what redundant, immaterial, impertinent, and scandalous are, they include allegations that constitute a needless repetition of other averments, so that the exhibits and the complaint allude repeatedly to the alleged motivations of Mr. York, for example. In some ways, they allude to the alleged motivations of Ms. Mathews. And they are repetitive, those allegations and conclusions about what those motivations are. Needlessly so. It confuses a reader. It confused me as I read the complaint. And if this complaint were to go to the jury, it would be unusual in a civil case, not unheard of for the complaint to go to the jury, but unusual. There is no way this complaint is going to the finder of fact in this case. not possible. An easy analogy I would draw is in this room, we try cases of child sexual assault, child abuse, and child pornography. This is not such a case. The allegations don't rise to that level. But even in the context of a burden of proof of beyond a reasonable doubt, I would never allow a complaint like this to be lodged. It is too prejudicial to the persons accused of torts in this case. It is too voluminous and confusing. Immaterial matters have no essential or important relationship to the claim for relief where the defense is being pleaded. So offers of compromise fall squarely and directly and completely into that description. Impertinent matters consist of statements that do not pertain and are not necessary to the issues in question. I'm going to quote a federal district court case in a moment, and in the federal district court case, Chief Judge Roger Hunt, here the Nevada District Court, when he was the chief judge, cut up a complaint in a somewhat similar set of facts to this case, and issued a detailed order that was about 3 pages long, suggesting line and paragraphs of the complaint that were stricken pursuant to his order using federal rules of civil procedure 8 and 12, which are the exact copies of Nevada rules of civil procedure 8 and 12. And at first I tried in my mind intellectually to cut up the complaint the way it's crafted, and I couldn't do it. I couldn't do it in a way that would be fair to Ms. Mathews and my worldview that the assertions are true, and in a way that would make sense. And scandalous material is described as allegations that cast a cruelly derogatory light on a party or other person. I am mindful that this complaint has been filed in a public case. The pleadings that I have been provided by the opponents to the complaint assert that the complaint was attached with a hyperlink and the exhibits to a press release issued in January of this year related to the complaint. I'm aware that participants in the case have chosen to ventilate their views about their respective positions on the front page of the Reno Gazette-Journal. Given the subject matter of this case, which is incredibly important, the allegations raised in this case, which are incredibly serious, we will do better than that. This is not a Jerry Springer show. This is not a circumstance where these assertions and allegations will be tried to the press or to members of the public who may be interested, or to anyone other than the finder of fact. An instructive, persuasive authority that informs my decision this afternoon is in a case entitled Mazzeo versus Gibbons. That's at 649 Fed Sub 2nd, 1182, out of the Nevada District Court in 2009. You all may recall, you may not recall, some of you may have been involved in litigation, I don't know, but then Senator Gibbons in 2006, while he was a candidate for governor of the state of Nevada, was accused by a woman of sexual harassment for an incident that allegedly occurred after drinking at a public place in a public parking garage. Mr. Gibbons was not ultimately charged with crimes, although the police investigated, and there's much controversy about the why he wasn't charged. But he was ultimately sued by Ms. Mazzeo related to the incident and the allegations of the incident. And during that lawsuit, Judge Hunt cited, again, the Federal District Court rules of civil procedure, 8 and 12, which are exact copies of Nevada rules of civil procedure, and pointed out, quote, in this rare instance, the court feels compelled to sua sponte strike certain portions of the complaint. Mazzeo's pleading includes inappropriate commentary, dramatic flourishes, deviating from the directive that she need provide only a short and plain statement of her claims. This is not a short and plain statement of claims. There are no doubt many motivations behind filing such a complaint. Those motivations may be legitimate, they may be illegitimate, or a mixture of the two. It matters not really to me what the motivations were. And again, I assume the assertions of the complaint to be true. Again, at the juncture in this case at which I'm viewing them, which is of course a motion to dismiss before there's even been a responsive answer filed by Ms. York or her entities. But when I look at persuasive authority, controlling case law, and make other observations, it becomes quite clear to me that the reference, for example, at page 13 of the complaint, at line, really begins on page 12, there's a paragraph number 56 that paints the picture of what I'm going to call the altar, for lack of a better way to describe it. And that I would be able to describe it as an altar speaks to why it is flourish and largesse in language and not language designed to give notice. But the language that paints the picture of the altar says that on top of the elevated chair were several items, including a whipped cream can, suction cup type apparatus, quote, which Mathews later found out to be a, quote, I'm not going to use the word plumper, because the word that is contained in the complaint is a derogatory, pejorative, negative description of a piece of a woman's anatomy. Now, if Mr. York used that, or wanted to use that tool, or described it as such, shame on him. It's not happening in this room. It is not happening in this room. That is but one example of the poetic flourishes that pervade this complaint. A gentle observation, Mr. Guinasso, please, this is not even a criticism. I have made this mistake myself so many times I can't tell you, but the very last page of the complaint, in page 41, line 13, under the title jury trial demand says, pursuant to the federal rules of civil procedure, a jury is demanded in this case. Of course, we're not operating under the federal rules of civil procedure, and so the complaint needs to be amended anyway, because it begins and ends with challenges. And so for all of those reasons, looking, for example, to Forte versus County of Merced, this is an Eastern District of California case. The Westlaw reference is 4745923. Name-calling, mudslinging, scandalous pleadings, and hostility towards opposing counsel undermine the integrity of judicial proceedings. There have been flavors of that, and they begin with the complaint in this case. I act as an arbiter of disputes as to the law that governs the proceedings and a gatekeeper with regard to the relevance of facts that the parties present to the court or seek to introduce in evidence. Acting as a gatekeeper, applying the Nevada rules of civil procedure, I strike the complaint in its entirety. I can't recraft it in a way that will meaningfully address the concerns I've identified. That is without prejudice to the plaintiff's ability to file an amended complaint. I'd like to offer some commentary about perhaps some guideposts of that amended complaint, meant in a helpful way. There is a motion to dismiss, which I've alluded to already, which I will stay pending amendment of the complaint. I would suggest that any drafter of an amended complaint pay particular attention, as I know you do, Mr. Guinasso, to the weaknesses identified by the motion to dismiss in the complaint. That would, of course, be what would happen if I granted a motion to dismiss in any event. It would likely result in my permission to you to simply amend the complaint to address the deficiencies described. I would suggest that less is more. As I've already alluded to, this complaint was meant for an audience different than me. I believe, through the lens I'm describing today, the assertions, at least against Mr. York, are true. prove it at trial. Don't try this case to the press. Don't try it to popular opinion. Don't try it to the audience. Try it to me and the jury. And craft the complaint with that goal in mind. Questions? First, Mr. Guinasso, for purposes of understanding my ruling. I'll craft the order striking the complaint, incorporating the resources that I believe are appropriate. Questions, Mr. Guinasso? Or would you like to play something into the record and then ask any questions?
Let me catch my breath for a moment here, because the direction you took was unexpected for me.
I'm sure.
The
We can take a break if you'd like.
No, it's fine. I just want to gather my thoughts because this isn't the first complaint I've ever filed, and there are certain cases where I plead the complaint with more particularity, both for the court and also for the public, because there are matters of public concern, there are issues that are weighty and important, and I never do these things frivolously with the idea of dishonoring the bar that I represent or personally attacking individuals. I just bring complaints, whether it's sex trafficking complaints, sex assault complaints, or sexual harassment complaints like this one. And so,
May I please interrupt as you continue to gather your thoughts, because I think it'll be helpful for our conversation. I get it, Mr. Guinasso, but nowhere in the rule does it say you get to draft to the audience. It doesn't say that you get to draft to the public. It says a short, plain, concise statement of the facts to give the defendant or defendants notice of the claims. Because taken to its logical extreme, what you would describe, I was a sex crimes prosecutor. I'm death on sex trafficking in this community. People who come into this room charged with sex crimes and plead guilty or found guilty. Sex trafficking crimes, they go to prison. But even in those cases, I would not allow a complaint that alleges the kind of detail and impertinent material that's alleged in this. You don't have to agree with that, I only make it so that hopefully the logic of my thinking is clear. Go ahead.
okay, thank you, Your Honor. Well, then my question simply is this, if I understand your ruling, you're striking the complaint, but you're giving leave to amend with the guidelines that you articulated just a few moments ago.
Correct.
All right, and the motion to dismiss is currently pending, will be stayed.
Correct.
And after our amended complaint is filed, then we will proceed. Is that right?
Yes.
Okay. And then with regard to the other named defendant, Mr. York, do we want to stay, or how does your ruling affect? Because he's already filed an answer in the case, and we have 16.1 and other things.
I would recommend that we hit the reset button. What I mean by that is all of the motion work thus far is understandably colored by and informed by the complaint as it exists. There are issues related to disqualification, but even those are colored by and affected by what is in the complaint or what isn't in the complaint, or both. And I'm open to discussion procedurally after my ruling is consummated and everybody's had an opportunity to make a record to discuss what we should do, but what I have in mind is we hit the reset button. I have repeatedly acknowledged the issues in this case are extremely important. As a consequence, we should take all the time we need to take to get it right. And in my view, the most efficacious, cautious, deliberate way to proceed would be to hit the pause button until that complaint hits, let the motion to dismiss or motions to dismiss, as the case may be renewed or lodged. Counsel for Mr. York would have an opportunity, of course, to file a motion to dismiss in light of an amended complaint, if that was his desire. I'm not inviting it or suggesting it, but that opportunity would be there. And let us separate the wheat from the chaff, as it were. Just my thought.
Thank you, Your Honor. And then the final question with regard to this motion to disqualify that appeared to be filed as a responsive pleading. It was filed 4 days before the motion to dismiss. how do you want to handle that?
Well, the motion to dismiss is ripe, in my view. What I mean by that is I know you filed a motion to strike, which I deny. And the reason I deny it is the basis for your motion to strike was, well, there's only the opportunity for responsive pleading. Respectfully, I adopt the points of authority cited by Mr. Simons for the proposition that the two are disconnected, meaning the answer, which is the responsive pleading or a motion to dismiss, is one thing. Disqualification issues, sort of like jurisdiction issues, are another thing altogether. And so I decline the motion to strike, the motion to disqualify. We'll talk about how far down the path of the motion to disqualify we're going to get here in a few moments. I hope that answers your question.
Should I make a record with regard to your denial of the
If
motion
you'd
to
like.
strike right now?
Sure.
Or should I wait until you take up that issue in a few moments?
Whenever it works for you.
Okay, Your Honor. I would just note a few things that, number one, with regard to ethics complaints, there are remedies for ethics complaints. There's the Nevada State Bar. Number two, if the crimes that are alleged in here, fraud, extortion, those things are real things, there's a remedy for that. You file a police report. Number three, if the torts that are alleged in the motion to disqualify are true and correct, there's a remedy for that. It's a civil action or a counterclaim. But it's wholly inappropriate to file a motion to disqualify as a responsive pleading. The case law is pretty clear that the motion to disqualify should come on the eve of trial if I become a material witness, not prior to the commencement of litigation, before there's been any discovery, before there's been any counterclaims. I mean, the things that I've been accused of in the motion to disqualify aren't even a part of a cause of action. And so I'm somewhat incredulous that that would be an appropriate pleading. It seems to me to be a rogue pleading that should be stricken and refiled, at an appropriate date and time after there's, the case has matured and there's been discovery and other actions have been taken by the defendant to perhaps become a plaintiff or perhaps become, or perhaps pursue other remedies. But using a motion to disqualify with what I would term are grossly incivil accusations against another member of the bar, this isn't, like a civil action where I'm bringing complaints against entities, against individuals, which is my right to do. What was put on the record in a motion to disqualify were direct attacks on my character, direct attacks on my motivations, and those might be appropriate for a civil action against me. Those might be appropriate in a criminal action, but in a motion to disqualify, prior to the complaint even being considered or before any adjudication of the case, just seems to me to be wholly inappropriate.
And the only thing I put into the record is I think you're perhaps understandably upset about the nature of the motion to disqualify, but I think you're reading too much in to my denial of a motion to strike. All I said was, you asked me to strike it because you said it wasn't responsive pleading. Much of what you just argued isn't in your motion to strike, and I'm not criticizing that, I'm just observing that. All I did was deny the motion to strike. Do you want to place anything into the record about the denial of the motion to strike?
No. But I have stuff to say about the motion to dismiss it at the appropriate time.
Okay. Anything you would like to place into the record? I don't think you have standing, but just so I don't ignore you.
No, Your Honor.
All right. So you want to be heard, it sounds, Mr. Simons, about my decision to stay the motion to dismiss. Is that correct?
That's correct, Your Honor.
Go ahead.
There's a consequence for the conduct that was undertaken by plaintiff's counsel. There's a consequence. You've stated repeatedly, you have to take what they allege as true, the factual allegations. They factually alleged repeatedly that Ms. York, in her individual capacity, acted at all times, at all relevant times, paragraph 2 of the amended complaint, as an agent of the corporation. This is there has to be some limits on what you're allowing them to change in terms of facts. And you recognize there's not a single allegation against Ms. York acting outside her agency status with the entity. In chapter 78, 747.1, an agent of a company does not have individual liability. So there's a consequence for what they said. That's one. Now let's go to the allegations against Inc., the corporation. Again, made up claims. They change, as you know, their cause of action 6 and 7 was based upon an employment contract. They pled an employment contract that Ms. Mathews had with the company. Motion to dismiss on that because you cannot intentionally interfere with your own contract. What do they actually say in their opposition? That it's a different contract. We're not talking about a contract, we're talking about the contract with Law Profits. But if you go through paragraphs after paragraph in their cause of action 6 and 7, it talks about the employment relationship with Inc. It adopts the employee handbook, the working conditions and their employment conditions. They say that in their pleading, it's a judicial admission, and they're bound by those factual assertions. In their opposition, they say, no, you misunderstood. We're talking about an entirely different contract. There's a consequence for that. And I believe they have to be held to what they've already pled. They haven't pled alter ego. They came up with that concept after you looked at 384 pages where they came in, they pled themselves out of court. And here's what I'm concerned about is you're giving him another shot at recrafting. I'm going to take another bite at this apple, and that's what concerns me.
I would do that in any other case. You and I both know the Supreme Court of Nevada and the United States Supreme Court have reinforced repeatedly the proposition that matters should be resolved on their merits. And in the context of a motion to dismiss and a request, as has been made in this case, for the ability to amend if any motion to dismiss is granted, there is liberal permission to do so. But again, I think you're reading too much like your colleague, Mr. Guinasso, into my ruling. I'm not saying the amended complaint will survive. The challenge for the pleader of a complaint like this is their assertions remain their assertions. The fact that I've stricken it as the complaint doesn't mean I can't consider it or you can't consider it. Just means that it's not the operative document as a complaint.
I think I understand what you're saying. I recognize that we're approaching this in a unique way because it's a sua sponte act versus a resolution of the motion. I'm trying to be cognizant and respectful of that.
And I've hit you all with a surprise, I know.
So, but the reason you have undertaken sua sponte activity is because of a pending motion we brought before you and briefed. And that, I come back to there's a consequence of the actions that were taken. But I understand your ruling.
I appreciate that. Mr. Gilmore, did you want to weigh in?
Well, he's thinking, I still want to talk about the motion for disqualification.
Of course.
Your Honor, I don't believe that I have much to add other than to clarify what the reset button exactly is. Because this is a Rule 12 order, whether it's sua sponte or as a result of a motion, the effect now is leaving this courtroom with the court's order. There is no complaint at issue. That would, I think, necessarily require a stay of all discovery. That might potentially require an additional early case conference and joint case conference report and all of those things. So I just wanted to confirm that this is really nothing more than what would happen if the court were to grant the motion with leave to amend without prejudice. We're essentially in the same place.
You're exactly right.
Then I have nothing further to add.
You're exactly right. So this obviates, of course, the motions to quash, I think, and the request for judicial notice and oppositions, unless we dive into the motion to disqualify. Here's why I use the qualifier, unless. I am not ruling on the motion to disqualify by these comments. This is not an advisory opinion. These are instead observations. My lengthy research with the assistance of my staff, into the disqualification issue leads me to one observation, which is that in general, Mr. Guinasso is right about when the issue of disqualification becomes a remedy that I must assert in a case like this. And that is when an attorney is a necessary witness at trial. I am more than prepared to be dissuaded of that by subsequent pleading or argument, but it would seem to me that in addition to that observation, what understandably Ms. York and Inc. are asking for, understandably I think under the circumstances, are to break down the door of the attorney-client privilege. And the specific assertion is fraud. It would seem to me that before I would break down the door of the attorney-client privilege, because it's not a door I can build back, right? If I'm wrong about invading Ms. Mathews' attorney-client privilege, I can't unring those bells. And so it would seem to me before I would take such a step as to allow the subpoenas which issued, for example, for personal communications between Ms. Mathews and her attorney, I would have to have a whole lot more information by way of competent evidence that would convince me that the reason to pierce the privilege, i.e. allegations of criminal or fraudulent intent, actually exist, which would require an evidentiary hearing. And I offer again my observation to all of you that hitting the reset button for purposes of a new complaint is helpful. The allegations of conflict are inimically wrapped up into the allegations of this complaint. They're just interwoven. I can't separate one from the other. And that's part of the challenge. And so I do not believe it is appropriate to undertake an evidentiary hearing today related to the motion to disqualify. It's your motion, I'll let you respond.
There's two different parts of the rule, the disqualification rule 1.78. One, I agree with you, is the attorney advocate rule, where the witness advocate rule, where the attorney, just like Mr. Guinasso, attach his own declaration disavowing a document to the complaint. Well, he necessarily made himself a witness with regard to that.
Maybe not a necessary witness, that's my only quarrel. Hang on, this will be helpful to you. I realize I'm interrupting you, and I mean to be helpful. Look, you and I both know, Mr. Simons, every time we interview a witness for trial, meaning a witness who we're going to call at trial, and we interview them, we become a potential witness because they may make inconsistent statements during our interview with them. This issue has long been litigated with me in criminal cases where I was the prosecutor and the claim from the defense was, well, I now have to impeach my own witness. Well, we all know that that's not true because I'm not a necessary witness. Why? Because my investigator was sitting right there. And as to some of these issues with her connection to Hutchinson and Stephenson and Mr. Guinasso, there are others who can be witnesses to that information. That's the only point I was trying to make.
Okay.
There's a distinction between necessary and potential.
Well, let me just stop on that necessary part. Who else is going to come in and say that that's a forgery? He said it's my signature and it's a forgery. There's nobody else's.
That's not true. His secretary, under our common law,
Okay,
we have an evidentiary rule that says somebody's familiar with his signature. We say it's not his signature.
Well, step 2. Step 2 talks about when there is testimony against each other under Rule 1.7A2. And this is in our, what we pointed out, in their opposition, they don't even tell you the subject, the substance of the rule.
Yeah, I haven't decided yet whether to sanction our friend or not. You know from misfortune with that rule, Mr. Simons, with me, I'm death on incomplete citations. It is the bane of my existence for an officer of the court to come in and misquote a rule, including operative language, which appears to have happened.
Agreed. Moving forward from that is if an attorney has to, or a law firm, are witnesses in a case, and the case, Sinazaro says, Rule 1.7 essentially precludes an attorney from taking a position that is adverse to another client's interest. So the attorney cannot be adverse to their client. The firm cannot be adverse. Remember, what they did was assert claims of fraud. They asserted claims of Chapter 613 and Title 7 in their demand that they attached. That's out there. They published it. They sent it out to the rural counties. They have it on their website. You can look at all this. They're bound by it. They make extortion demands on my client, asserting that she is liable for hundreds of thousands of dollars.
Well, that's a conclusory statement is the problem. That is your conclusion. I'm not making that factual conclusion.
No, I am saying what is the situation from my perspective. I'm advocating that position. They attach that demand. And then they file press releases and they file their opposition saying she's not liable under those claims because they're not valid against the entity because it has less than 15 employees. So they make assertions of fact that say, we're going to assert these claims against you and you're liable, Ms. York and your company, to pay us. Oh, and you owe us $10,000 in legal fees we've incurred, which we know that's not true. So they're extorting money. They all know their statement were false. Because in subsequent documents before this court, they admit those claims don't exist. And in its press release, these claims are not viable. So here's what we have in this situation is, let's not forget the great one, but the claims of defamation. And then they go and republish and send out all the defamatory material. So then I get to use Mr. Guinasso, who's the author of the press release, and who's the individual who sent this to everybody in the Western Hemisphere, that, look, you can't prove any damages. You can't prove causation. So I'm going to use his words out of his mouth against his client. That creates a conflict.
Well, the conflict is of your creation, intellectually. It is not a conflict that he is asserting against her or that she's asserting against him. What that rule is intended for is to prevent a client from suing their own attorney or vice versa within the lawsuit. In this case, you're using shields and swords interchangeably, cleverly and appropriately. It may have merit, I don't know. But I don't believe that's the kind of conflict the rule is talking about. And my only point in interrupting and offering that to you is this. You have to, if what you want to do today is dive into an evidentiary hearing related to this motion to disqualify, really you've got to convince me it's a good idea. And what I mean by that is this. I see it as premature. I have stricken the complaint. That is extraordinary in any case. It may be amended. I assume it will be. And I would suggest any conversations we have about Mr. Guinasso's involvement, the implications of and consequences of the stricken complaint, please, I offer this comment as cautiously as I can. Sanctions related to the complaint, etc., those are questions for a different day.
Can I have a moment?
Yes.
So can we take a break so I can confer with my client?
Absolutely, I think that's appropriate. Thank you for the request. We'll be in recess until you call, Mr. Simons.
Thank you.
All rise. All rise. This court is again in session.
Thank you very much for that courtesy. Please be seated, ladies and gentlemen. This is again CD 22-02069, generally entitled Mathews versus York. All parties are present with their respective counsel. You appropriately asked for a recess to collect your thoughts. I had interrupted your train of thought. Mr. Simons.
Given the change of the playing field from your sua sponte order, we agree that it is premature to move forward at this time since there's not a pending complaint on file. So the effect is to move the motion to the extent I need to say we reserve the right should the issue rise in the future to bring it, but I don't even think I have the ability to reserve the right. But I just want to put that on the record to the extent that you had any confusion as to our position.
I appreciate you making the record. Thank you for that discretion. Would appear to me that then, short of my order, written order confirming the strike, our business is done today. Mr. Guinasso?
Yes, Your Honor.
Mr. Simons?
You're correct.
Mr. Gilmore?
I agree.
All right. Folks, please take good care of yourselves. 4 judges, the district judges last week, have tested positive for COVID, not from the second, but inevitably that means many more are carriers, hopefully not me included. Take care of your families. Good day to you all.
All rise.